Can a state require that the 10 Commandments be posted in every classroom? What does the Establishment Clause mean these days with the rise of the Free Exercise Clause and the impact of Kennedy versus Bremerton? Jamie, do you ever get deja vu? Have we had this conversation already?
Rinse and repeat, buddy. Rinse and repeat. Here we go again. We've called these things hydra laws. When one gets struck down, two more seem to pop up. We could call it Groundhog Day episodes. Whatever you want to call it. Yeah, whatever you want to call it. We've got another First Amendment religion case for you folks today. This is the case of Roake versus Brumley. This is a recent case out of Louisiana concerning a state law that requires public schools to display the Protestant version of the 10 Commandments. Strict formatting requirements too, like you've got to display them this way, in this font, and all that kind of stuff. So yeah, that's right. We're back with another church-state case. What do you think, Chris? Are we seeing a pattern here?
No.
No, yeah, I think we are actually.
No.
Like, make it stop, man. This is enough. Can we move on, please?
This is what happens when you shake up precedent, right? Like, we've got to refight a lot of the same fights, and this is a fight that we fought in the 1980s. Well, I didn't fight it, Jamie. I don't think you did either.
No.
But they fought it in the 1980s, and it's back.
It's back. Yeah. Here we go again.
Groundhog law is good. I like that.
It's like that scene from Spaceballs. We're fighting this fight again. It's Rocky 5000. All right. Well, welcome to Chalk and Gavel, everybody, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, bringing you the fascinating stories, connecting the courtroom to the classroom.
Again.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
Okay, welcome back to the show, everybody. Don't forget, please rate and review Chalk and Gavel. If you're checking us out on YouTube, please give this video a thumbs up. All of that will help us spread the word. We also have a teaching guide available on our website, chalkandgavel.com, and we would love it if you would consider supporting our show on Patreon for just $2 a month. You can go to patreon.com/chalkandgavel to help us keep bringing you all of this fun school law stuff over and over and over again. Speaking of fun school law stuff, what is our bell ringer, sir?
I don't know if I can live up to that transition, but I've got an update for you on some of the Trump administration's efforts to shutter the U.S. Department of Education.
Okay,
it was
good.
a big campaign.
Fun.
Right, yeah. Fun. Yeah, I know. Yeah. I told you. We probably should have talked about that before we did it, but that's all right. So we talked about this in the spring when President Trump announced that the Department of Education was going to lay off around 1,400 employees, which would put the department at about half the size as it was compared to when Trump took office. So it still leaves around 2,000 employees at the U.S. Department of Education, which is down from a little bit under 4,000 in January of 25. So, we talked about these layoffs. They hit a lot of groups differently. So one of the biggest layoffs was like the Office for Civil Rights, and a lot of their civil rights enforcement attorneys and staff were a big part of this, where entire offices were closed. But a number, and we talked about this too, a number of folks brought some lawsuits challenging these layoffs, essentially arguing that they exceeded the executive's authority because they weren't just kind of normal employment decisions. Instead, it was really just a closing of the Department of Education by another name, which only the Congress can do through a statute. And so these lawsuits have been going on, and a lower court in Boston actually issued an injunction stopping the layoffs from going into effect. But that injunction was ultimately appealed to the United States Supreme Court, who on their shadow docket lifted the injunction. So what that means is that the layoffs can go forward while the lawsuits challenging them also proceed. So this isn't the final word, but it essentially allows the layoffs to go into effect, even though there are lawsuits going on right now challenging them. And, there's a few interesting things here that I just kind of want to highlight and discuss. First is that this was an emergency appeal. So usually when we're talking about the Supreme Court, we're talking about one of their merits decisions where, we get oral argument, we get briefings, we get in front of the court. There's a huge long process. It takes the entire year to basically hear a case and decide it. But with the emergency docket, these things go really fast. And they're usually these kind of injunctions or things that have to happen in a timely manner. And there's been a increase in the number and significance of cases that the court has taken up on the shadow docket. And it's been typically falling along party lines or ideological lines, rather. So this was a 6-3 decision. And one of the things about the shadow docket is that the justices don't publish opinions about why they did what they did. They just kind of submit an order. But in this case, the dissenting justices, which are the 3 liberal justices, in an opinion written by Justice Sotomayor, they wrote a dissenting opinion and they didn't really mince words. So Justice Sotomayor says in the dissent, when the executive publicly announces its intent to break the law and then executes on that promise, it is the judiciary's duty to check that lawlessness, not expedite it. Yeah, I don't think things are going very well at the Supreme Court right now.
I would not want to be in the break room.
Right? Yeah,
it's probably a little bit of tension there.
You got to imagine, because there are stories of Ginsburg and Scalia, who are both titans of the court in the recent decades, going to the opera together and having this kind of cordial relationship. I'm wondering if that's still the case, given some of the language coming out in these opinions.
Yeah, no, I don't think anybody's going to the opera together, or at least not one from the 6 side and one from the 3 side.
Definitely not Alito and Sotomayor. Let's just say that.
No. Yeah.
But, the bigger thing here is the shadow docket is, it's a little worrisome because there's not as much transparency, and the lack of justification really kind of opens up a lot of questions because the Supreme Court with the shadow docket has done some things that are challenging existing precedent, but they haven't said why they're doing it or if that precedent is still in good law or if the shadow docket opinions have the force and effect of law that lower courts have to then kind of read the tea leaves about what to do. So there's so much questions here. And obviously this has a huge implications for the Department of Education, but it also has implications for, our larger system of the rule of law and the nature of the Supreme Court. So it's something that we're keeping an eye on. And it seems to be right now, at least, very much a ideological tool in a lot of ways, because a lot of lower courts are blocking Trump administration policies, but then it gets up to the Supreme Court and on the shadow docket, they lift those roadblocks. It's one of those very strange situations that hopefully the court corrects course and goes back to a more transparent process.
I think with everything that has gone on over the last few years or whatever, and I just think that we're not going to gain any clarity on essentially the long-term impact of all of this. We're not going to be able to predict, like you said, with the tea leaves and everything. I don't think we're going to be able to predict any sort of long-term impact because everything is just so Twilight Zone-y right now. It's, we're going to have to wait 10 years, unfortunately, to kind of see how all of this stuff plays out. And on one hand, that's not uncommon. It's hard to know how something is going to play out long term until it plays out long term. But we've talked so much on the show about how, we have had 50 or 100 years of precedent that have given us good indicators of how things will probably play out. And that precedent it just feels like it's continually being, upended.
Yeah. We're no longer standing on firm ground. It feels like we're always on shifting sand.
Yes.
But that is why I was so excited to do this case, because this case is, I think, a fantastic example of they're shifting ground. We decided this issue in 1980 with almost the exact same law.
Yeah.
But we've got a new law, a new court case, but we've got there's precedent that has changed in between. And this case to me is all about the conflict of making sense of that precedent. So like, Jamie, to your point, there's going to be years of ramifications here, but it's not a passive process. It's very much an interpretive process where, these things are coming out, and, there are people who are, trying to make sense of this, and also who are shaping the interpretation of these larger things. And so like, it's very much a dialectic process where like all of this is going on all the time. And I think this case does a fantastic job of showing that work in practice. So you want to get into it?
Yeah, no, absolutely. Let's get into it. So basically, this case is another church-state case, 10 Commandments in schools. That's what this case has to do with. We've talked about it a few times. We covered the initial passage of the law in one of our bell ringers, episode 21. We covered the lower court injunction that prevented the enforcement of the law, which was requiring schools to display the 10 Commandments in classrooms. We covered that in episode 31. We poked a little bit of fun at this whole thing in the live show that we did from the Education Law Association annual conference. That was episode 34, our New Year's Eve episode.
Right.
I think that might have been our first video one. Yeah.
Yeah. Thou shalt not wear pink on Wednesdays.
Yeah. So like there were a lot of people that were kind of poking fun at this law and trying to be compliant with the law in very interesting, fun, and creative ways. Mm-hmm. So we talked about that in episode 34. But now we've got the Fifth Circuit Court of Appeals decision on this Louisiana law, and that's what we're going to talk about today. So we're going to do the whole episode today on this particular 10 Commandments case out of Louisiana. Are you ready?
And interestingly, Texas just passed a very similar law. So we'll have to see what happens with that one too.
Okay. Just
speaking of Groundhog Day.
Yeah, not surprised. Okay, so here are the facts in the Louisiana case. Don't forget, this is all just at the preliminary sort of injunction stage, so the fact record here is sparse, considering this hasn't the statute never went into effect. This hasn't fully, played out in the courts, where both sides have been able to give all of their info. So here we go. In June of 2024, Louisiana's governor signed a law, House Bill 71, and that law says that, quote, no later than January 1st, 2025, each public school governing authority shall display the 10 Commandments in each classroom in each school under its jurisdiction, unquote.
Okay.
All right. So that law says that at a minimum, the 10 Commandments display, not a minimum of 10 commandments.
You must display at least five of the 10 commandments.
At minimum, the 10 Commandments display must be a poster or a framed document that is at least 11 by 14 inches, not feet, with the text of the 10 Commandments being, quote, the central focus of the poster, unquote, printed in, quote, large, easily readable font, unquote.
Whoever wrote this law, I think, has small children.
They watched our episode 34.
They might have, yeah.
No, they didn't, because this was before episode 34 came out. But
like, they're being so prescriptive because they're like, no, you can't put it on a postage stamp and put it on your wall. That's not going to do it.
Right.
No, you can't.
They're trying to
invisible ink.
Yeah,
right?
They're trying to anticipate people finding creative ways to kind of get around this if they don't believe in its value or appropriateness or whatever of the law, not necessarily of the 10 Commandments. We're just talking about the law. So, I mean, I'm sure there are people who might not agree with the 10 Commandments. But anyway.
Amazing in a religiously diverse country.
So the law also required that posters be accompanied by a context statement about the history of the 10 Commandments in American public discourse, American public education. And the law said that the 10 Commandments could be displayed with other important foundational documents like the Mayflower Compact, the Declaration of Independence, the Northwest Ordinance, all these other things. To me, it just sounds like they're trying to, if it walks like a duck and quacks like a duck,
Right. Well, yeah, they're trying to have their cake and eat it too.
Yeah, and they're trying to justify and make it sound like
this isn't about religion.
This is not about religion, right?
That's 100% what it is, because it's saying like, we're putting this in here because of the relationship of the 10 Commandments to kind of the founding of our nation and like these ideals, which, I think we talked about this in the past, like that is in many ways like at the very least an oversimplification of the role of religion in our founding, but also probably like a distortion of that story, because like if that was the case, then why did we have the Establishment Clause in our Constitution?
In the first place? Yeah.
Right. And like there's so much, and we talk about the founding fathers, like that's a monolithic thing, but they had such diverse ideas about the role of religion. Like, you look at Jefferson, for example, but like, I think, they're trying to have their cake and eat it too, but like they're trying to put their cake into like a broccoli like casserole and pretend it's pretend it's healthy, right? Like they're trying to hide the religious intent behind this kind of larger secular thing, which I think is most clearly indicated by the shall versus the may. Like you shall post the 10 Commandments, but you may post these other documents.
Yeah.
So like, which is the more important one? Well, it's clearly the 10 Commandments.
I really appreciated your broccoli casserole.
I was worried that was too Midwest.
Well, what I will tell you, what was going through my head was, if you cover a turd in chocolate, it's still a turd.
Yeah, no, right. I think both play.
Shall we keep going?
Please.
So interestingly, that law provided that public school officials are not required to pay for the displays themselves, but could instead accept donated funds to pay for them, or just accept donated displays.
Right. And that again kind of shows that the people who passed this law kind of know what's up, where they're worried about the expenditure of government funds paying for a religious display.
Yeah, the entanglement piece, right?
That sounds like a keyword.
Yes, that's, I know my law.
Hey, you should teach this stuff.
Anyway, so last thing, the law directs the Louisiana Board of Elementary and Secondary Education to adopt rules and regulations to implement the 10 Commandments requirement. So schools had until technically the beginning of 2025, about 8 months ago or so, to post the 10 Commandments in every classroom in the state, including colleges and universities. But here we are, 8 months later. Did that happen, Chris, or did it not happen?
No. And you want to know why?
I do.
Because a bunch of people filed a lawsuit.
Really?
Yeah, I know what we're talking about on Chalk and Gavel. So there I feel like
that's what we do.
Takes the wind out of my wings when I say that. But because it's kind of just a given. Anyway, on June 24th, so less than a month after this law got signed into law, a group of individuals from multiple faiths and from no religious affiliation, a bunch of parents on behalf of themselves and their children brought a lawsuit challenging the constitutionality of the 10 Commandment requirement. So they alleged that the requirement violated the Establishment Clause, which prevents the government from kind of like putting its finger on the scale of religion. And they also argued that it violated the Free Exercise Clause of the First Amendment. Now, most of this case is decided on Establishment Clause grounds, but I think the Free Exercise Clause issue is really interesting in light of Mahmoud versus Taylor and the Supreme Court's new kind of recognition of a parental right to opt out. Because this, I think, raises some really interesting questions about the implications of Mahmoud and how that would play out in something like this.
I was thinking the exact same thing. After Mahmoud, you could theoretically, walk into a Louisiana classroom and say, I have to opt out of this entire classroom altogether because that is on the wall.
Right. And how do you do that if it's on every single wall?
Exactly.
Right? And that goes into like Alito kind of, he's in his argument, like he said that there's no de maximis exception.
Yep.
Right. And so if there's no de maximis exception, meaning that like just because there's so many violations doesn't mean you can get away with a violation, then that kind of shows that line between like the parents were saying, oh no, we're talking about opt out. We're not talking about the curriculum. But here, like, what if you can't be anywhere? Now you're talking about changing the structure of the schools if that child is still going to access it. So like, it does raise some really interesting questions about Mahmoud, right?
It definitely raises some interesting questions. And as much as I would like to say, with respect to this case, it would be very interesting to be able to say to Justice Alito, all right, buddy, you made your bed. Now you got to lie in it.
Right. Yeah.
That's not going to happen as of right now with this particular case. The spoiler alert here is the preliminary injunction was granted. We're going to talk about why, though.
Right. And it could still get appealed to the Supreme Court, I think.
Like, this is not done. Like, This is only saying when a preliminary injunction is granted, they're just saying, all right, you guys need to stop doing whatever you're doing right now until this thing can play out.
Right. Yeah. And so as of this recording, I don't think this has been appealed, and I don't know exactly what their time frame is for that, if they've already missed their window or not.
Right.
But, this could work its way up. We don't know. And I mean, kind of like what Oklahoma did with the Oklahoma Virtual Religious Charter School.
Yeah.
It feels like these states are kind of like testing the waters, basically to create test cases for the Supreme Court.
Yeah, it's going to be up to the Supreme Court to determine what they feel are the appropriate test cases to help sort of get their particular legal ideology through, whatever it is.
Right. Their understanding of the Constitution.
Exactly.
Right. Which is, leads me to one of my favorite thoughts about the Supreme Court. They're not always right, but they are last.
That's right.
So the plaintiffs filed this lawsuit, and they quickly moved for a preliminary injunction, which we've already kind of mentioned.
Yeah.
They wanted to halt the enforcement of this law and to keep it from going into effect, and not wanting to be left out, the state defendants, so the state of Louisiana, the Board of Education, all those folks, they actually moved to dismiss the case for Jamie.
It's got to be some kind of number in letters, 12.
12b-6, your favorite rule of civil procedure.
There it is.
So they moved to dismiss the case for failure to state a claim. They also moved, and we haven't talked about this rule of civil procedure, so this will help you when you go take that bar exam, 12b-1,
really?
Which argues that the court lacks subject matter jurisdiction, which is essentially like the court's authority to hear the case.
Okay.
And
that's an interesting one.
It is because those are kind of like procedural issues with the case that don't have anything to do with the merits. So like failure to state a claim is basically saying like, even if you agree with everything they say, they don't
break
win.
The law. Yeah, we didn't do anything wrong.
Yeah, but the procedural one is like very much like you're not the right court to hear this case, or these aren't the right people to bring it, or it's not the right time to bring the case. And, personally, I think that
that's a little bit of a stretch. Yeah.
Right. And it shows their strategy here because they know they've got bad law, right? Because Stone versus Graham settled this in the 1980s.
Yeah.
It's been the rule of the land for 50 years. But given recent Supreme Court decisions with things like Kennedy versus Bremerton, they're trying again. And, when the law isn't necessarily on your side, one of the tactics is to argue procedure. So like the process, and to basically say like, oh, well, this isn't the right process.
Yeah.
And so Louisiana here is essentially arguing that, this lawsuit is just too early because the law hasn't gone into effect. We don't know how it's going to be enforced. We don't know how it's going to hurt people, or if it's going to hurt people, or if it's going to harm them in any way. And the state is also saying that like, there's no enforcement yet. So like essentially like no harm, no foul at this point.
But one of the things that I found interesting about reading through this case was that the court looked at that and they were like, that doesn't fly with us because the law is pretty detailed, pretty specific, pretty prescriptive. Like we have enough information to know what this is going to look like when it does go into effect.
Right. And that's the whole issue here with all these procedural arguments. So like basically they're making arguments based on ripeness and standing. So ripeness is basically just saying that like this case isn't ready yet. It needs to bake a little bit longer because it's too abstract. It's too hypothetical. We don't really know what the hardships are going to be if the court digs into it right now. And then the standing issue is like, have you been injured, or can you show that you are imminently going to be injured in a way that the court can fix? And, for this, like the state is basically saying that no one knows when, how, or even if this is requirements going to be enforced. That's kind of their ripeness issue.
Mm-hmm.
And as you kind of pointed out, the court kind of deals with that pretty quickly, where they're like, this isn't very abstract. You told them that they had to post the 10 commandments. You told them how big it had to be. Yeah. You told them like this was pretty prescriptive.
Yeah.
And so that is pretty much done. And then that kind of also deals with the standing issue, which is like this idea of an injury in fact. And the state is basically arguing that the harm here isn't concrete, particularized, and imminent. And the court, again, disagrees and says like, and actually, this is a really interesting quote from the court. They say unwanted exposure to government-sponsored religious displays and exercises can, under certain circumstances, violate plaintiffs' First Amendment rights. And they go on to kind of say, particularly in schools, because of the nature of education and kind of the, the sensitive age and kind of the concern about coercion, which is unique to schools, right?
Yep, exactly.
But Jamie, if you thought those were bad arguments, you ready? This one takes the cake. Hey. Another cake reference. So the state also argues that they have sovereign immunity. So sovereign immunity is basically just a recognition that states are immune from lawsuits because they're sovereign in our system of government in a lot of ways. But there are some very significant exceptions to that immunity. One of those exceptions is if the case seeks to redress an ongoing violation of federal law. So how is Louisiana trying to get around that one?
Not well.
Yeah, no, it doesn't work. But this is the direct quote from the opinion, saying that the state is arguing that the state board's exercise of its authority to implement this law will not compel or constrain anyone to obey the challenged law.
Wait, what?
I know.
Hang on.
Yeah, no. Parse it out. Parse it out. Their argument is essentially
their argument is like, we're not telling you what to do, even though we're telling you what to do.
Right. Their argument is, I don't know, schools may or may not have to do the thing we said they had to do. And
oh my God.
I don't think that's a winner. And, maybe what they're saying is like, the law says that the state board has to implement this law and the state board hasn't had a chance to implement the law yet. So like, because they haven't done it, we don't actually know like what that's going to do, which ignores the text of the law, which says
you have to do this.
Put it in every classroom, right?
Like, come on.
So anyway, that's the procedural stuff.
Are they just, when they write this stuff up, are they just like taking their chances like, well, maybe nobody's going to read it?
No, we've talked about spaghetti lawsuits, right? Like you throw every argument and then like, they're on the back foot because they're the state, they're the defendants. Yeah. And so if you're the defendants, you just got to win on one of these procedural arguments and it's gone.
We don't care how we win. We don't care if our argument is complete nonsense.
Or contradictory,
if enough people believe it or agree with it or whatever, then I don't care.
If I get one trial court judge, 2 appellate court judges, or 5 members of the Supreme Court, I don't care.
Oh boy.
I know.
I would like to say, listeners, don't lose faith in the system.
Did you ever watch the cartoon Archer?
No, I have not.
Okay, there's a great line where I think he's an FBI official, tells one of the main characters, save it for 4 nights of the Supreme Court. And I think about that way too often.
That's...
Anyway, so that's the procedural arguments.
Okay.
What about the Establishment Clause?
Yeah,
because this is like the meat. This is the stuff that like...
Yeah.
So, we've talked about the Establishment Clause before, and one of the things that we've talked about a lot is that we're not really sure right now kind of the nature of the law surrounding the Establishment Clause, like what independent work is the Establishment Clause doing? But according to the court here, the way they describe it is the Establishment Clause was intended to erect a wall of separation between church and state, and that this means at a minimum that no federal or state government can pass laws which aid one religion, aid all religions, or prefer one religion over another.
Okay.
So that's kind of the like high level Establishment Clause.
So to go back to some of the conversations that we've had recently in other episodes, with Mahmoud and with Martha, when we talked about the Oklahoma case and everything, we talk about how the Establishment Clause, we've sort of likened it to a sword versus a shield, right?
Right.
And in some of those cases, it seems to be being used as a sword. And in other cases, it seems to be used as a shield. And
the Free Exercise Clause.
So the Free Exercise Clause. So in this case, so thank you for, So in this case, we've got the court that's basically saying, no, this establishment clause thing, that's a shield, right?
Right. And it shields individuals from governmental
overreach pressure
in regards to religion. Yeah.
Yes.
And that's kind of like, when we talked about the court's opinion, the Oklahoma Supreme Court's opinion, when they decided the Oklahoma Virtual Religious Charter School case, Drummond. Let's just call it Drummond, because Oklahoma Virtual Religious Charter School is just such a mouthful.
It's too much.
When they decided the Drummond case, they kind of grappled with what does the Establishment Clause mean? And because they said it violated the Establishment Clause in Oklahoma, at least. And the way they phrased it was kind of like almost like a negative free exercise clause, where the Establishment Clause creates a space for free exercise. So basically it prevents the state from putting their thumb on the scale of religion to basically shift the calculus in favor of one religion or any religion over non-religion.
Okay.
And I don't know if that's kind of that might be the direction that the court is going with it, because, the Oklahoma Supreme Court was pretty conservative, even though they did strike down the religious charter school. So, all that to say is the meaning of the Establishment Clause is in flux in many ways. And a big part of that is because of the recent Supreme Court case in Kennedy versus Bremerton, which we covered very early on, which was the case of the praying football coach.
Yeah.
And so in that case, the Supreme Court basically said for Establishment Clause cases, we're no longer going to apply the Lemon test, which was a test from the 1970s that had been really influential in kind of helping courts navigate Establishment Clause cases. And so, Lemon basically had courts looking at three things. You had to look at whether the law had a secular purpose. So was it justified in non-religious ways?
Yeah.
Whether its primary effect was to advance or inhibit religion. And, that included whether or not a reasonable observer would see it as an endorsement of religion.
Yeah.
And then the third one, whether or not it created an excessive entanglement with religion. Jamie, going back to our vocab word from earlier.
Yeah.
And the court in Kennedy said, we're not going to apply the Lemon test. Instead, our lesson from our recent cases is to look at history and tradition to help us understand what the Establishment Clause meant to those who enacted it at the time of its enactment. And so the state here, Louisiana, is essentially arguing that when Kennedy versus Bremerton repudiated the Lemon test, that means that Stone, which was from the 1980s, which applied the Lemon test, they said that that's no longer good law, so we need to do this again. So that's why they basically say we don't lose because Stone is no longer good law. Right. And so one of the big fights here is what does Kennedy mean in relation to Establishment Clause cases? Because Louisiana is essentially arguing that even though Kennedy didn't mention Stone, it didn't mention this case at all, it didn't explicitly overrule Stone, they're still saying that Kennedy basically means that Stone isn't good law. And the logical conclusion from that argument is that every Establishment Clause case since Lemon is no longer good law. And that's kind of the state's perspective. The court's perspective, on the other hand, is a little bit different. And they say that, Kennedy versus Bremerton didn't mention Stone. It didn't mention this case that you say got overruled. The Supreme Court didn't say they overruled it. It's not addressed anywhere. And the court basically says the only people who can overrule the Supreme Court are the Supreme Court. They're not always right. They are last.
Yes.
And so the court basically says you all might be right that Stone, we need to revisit Stone based on Kennedy, but that's
Kennedy
something for the Supreme.
Yeah.
Right. That's something for the Supreme Court to do.
Yeah.
And so the majority opinion here basically says until the Supreme Court
does
says
it,
otherwise. Yeah.
We're going to keep going with what we're
going to apply Stone.
Yeah.
And that I think is a really interesting part of this case, because there's also a concurring opinion, which actually would go kind of a step further. Instead of just saying no, Kennedy didn't overrule Stone, so we're still bound by Stone, the concurring opinion would have said that Kennedy only overruled the endorsement portion of the Lemon test, because according to the concurrence, a lot of those other concerns about having a secular purpose, about avoiding excessive entanglement, all of those concerns pre-existed Lemon. Lemon just kind of put them together into a framework. And so their argument is basically like the component pieces of Lemon are still good law, even if, that question about like, would a reasonable person see this as an endorsement of religion? Like that part is bad. Yeah. That's what Kennedy struck down. Yeah. And so it's really interesting to go back to our conversation earlier, like to see these judges and attorneys fighting over the meaning of this case. Yeah. This is just another example of how courts fight over the meaning of cases. We talked about this with Mahmoud and the meaning of Wisconsin versus Yoder, right? Yeah. And so like these cases aren't cut and dry, even when they seem cut and dry, because part of the process is people taking those cases and making sense of them.
Well, yeah. And we've talked about this a lot. We also talk about, I know I talk about this in my classes, but these court cases are often very narrow, right? They're very focused on the specific facts and circumstances of that particular case and issue. And one of the things that we're all trying to do here is interpret how those particular arguments in those particular contexts might apply in different contexts. Right. And, that's a huge part of the wrestling, of the argument, of the fighting, of the, whatever, right?
Yeah, it's one of the reasons why we say context matters so much.
Totally. Right? Which is why when all the students always ask us, okay, well, can you do this or can you do that or can you not do this? And the answer is always irritating to them because we say, well, it depends.
That's actually the first thing they teach you at law school on your first day. Yeah. They're just like, the answer to every legal question is it depends. The next 3 years is going to tell you on what it depends.
So if anybody ever wants to know how to disappoint a prospective school administrator in a school law class.
Or if anyone ever asks you a legal question.
Yeah. Just say, well, it depends. And
right. And, here it depends on how the court interprets Kennedy versus Bremerton and what that means for the Establishment Clause.
Yep. All right. So what next? What was the rest of it?
So the court here says that, Stone is still good law, so we're going to apply Stone. And if we apply Stone, Louisiana, you've got some problems because the law that was struck down in Stone is almost identical to what you've got going on here. So the Kentucky law that was struck down in 1980, it required the 10 Commandments to be posted in every classroom. It set out requirements for size and legibility. It also required inclusion of a secular purpose statement. And the Supreme Court looked at all of that and struck it down anyway and said, like,
that's BS.
Undeniably a religious text. And you really, just because you are trying to tack on a secular purpose, like that doesn't blind us to the fact that this is very much a religious statement, right?
It's the chocolate turd doctrine.
Right. It's the, I know it when I see it.
Yeah.
I can't wait to see that in a court opinion, Jamie.
Just make sure you cite Cudlitz and Thomas on chocolate turd.
Episode 51. All right. Yeah. So the other thing that was really important in Stone is the court basically said, like, look, if Kentucky wanted to teach about the 10 Commandments, that's totally cool. Like, we have no problem with that. It's the fact that this isn't part of the curriculum. Like, you can teach about the Bible, no problem. You just can't teach the Bible. But putting the 10 Commandments on the walls of every classroom isn't necessarily educational. It's not part of the curriculum. Like, what does the 10 Commandments have to do with geometry? Right? So that kind of undermines this curricular, secular argument. Right? And so the court here really doesn't see any difference between Louisiana's 10 Commandment law and the law under Stone. Right. It's still prescriptive. It requires it to be in every classroom, requires a certain size. It has these kind of tacked on secular purposes. And, even though it allows for these permissive additions of other founding documents, they're not required. And it doesn't really kind of hide the larger religious purpose behind these laws, especially when you look at some of the legislative history, which was very much we need to teach a very specific kind of morality that is grounded in kind of this Christian viewpoint. So the court looks at all of that and says there's enough here for me to not see any daylight between Stone and what you got going on. Right. So we're going to put that on pause. But the court goes even one further than that. They said that even if Stone were overruled tomorrow, Louisiana, you still lose, even under Kennedy versus Bremerton. And this is interesting because this is kind of getting into again, continuing the argument about like, what does Kennedy mean? Right. So Kennedy said, maybe we're not doing the Lemon Test, or maybe we're not doing parts of the Lemon Test. We need to look at history and tradition. But, history and tradition, that's not a monolithic thing.
Yeah.
There's a difference between ideas and practice and principles and aspirations. Like, we've got different people arguing for different things. We've got different local contexts. So like, my concern with history and tradition, let me get on a soapbox really fast, is it allows judges to look out over the crowd and pick out their friends, right? Like, history and tradition is something where like you can find something to support you, but like, is it the only thing? Are there other valid interpretations of history? Like,
so it's cherry picking.
Right. And that's like one of the big concerns. And, here, like a big part of the history and tradition thing is like, what is it that we are looking for a history of? And the court here defines that in a very narrow way. They say, like, we are looking for a history of school requirements that the 10 Commandments be posted in every classroom.
Yeah, interesting.
And so, like, that history, you're probably not going to be able to find that, right? But like, if you abstract that a little bit and say like, oh, we're looking for a history of religiously informed moral instruction, now you're in a little bit of a grayer area. All of that, like, to say, that's just some of the like the things that these courts are having to grapple with like this history and tradition thing.
Right.
And so here, interestingly, the plaintiffs did something really strategic. They had an expert witness testify at the preliminary hearing stage. And the expert witness was I believe they were a law professor who studies kind of the history of religion in education. And they testified that, there is no history of the 10 Commandments being displayed in public schools. And so, we've got this expert testimony saying there's a lack of a history and tradition here. The state, for its part, they tried to exclude the expert because, again, they're fighting about procedural stuff, but they didn't offer expert testimony of their own to say that, yes, there is. They just kind of put in the legislative statement of purpose that, like, there is a history and tradition here that we're respecting. And so the court says, like, okay, well, if I have to look at history and tradition, I've got enough here to support the plaintiffs that, if I accept everything they're saying is true, like, they have a likelihood of success on the case. So like, at this stage, I'm going to deny your motion, and I think I've got enough to issue the injunction based on the evidence that they've put on. So, bottom line is the Louisiana 10 Commandments violates the Establishment Clause, and the law is on hold. So the appellate court upholds the injunction.
Yeah. So here we're recording this in August of 2025. I think actually this episode is also coming out in August of 2025. And as of this recording, it remains in place. That preliminary injunction remains in place, which means that Louisiana cannot enforce this law while the litigation kind of continues. But that doesn't mean that that's the final say here, right? Like, there could be a full trial based on the merits. It could be appealed to the Supreme Court. The Supreme Court may or may not take it up if,
and they may not see it the same way, right?
Right. Anyway, it's just like, it's on hold, but it's fascinating because you're also, like you said at the beginning of the episode, we just had a law in Texas come into play. So who knows what's going to happen with that one because Texas is also Fifth Circuit, right? Isn't it?
I actually don't know the answer to that off the top of my head.
Because actually, if that's the case, and the Texas law, if Texas is part of the Fifth Circuit, they're bound by the Fifth Circuit Court of Appeals opinion. And so
they would have to argue that their law is different.
Yeah, exactly. So
no. We really have a secular purpose. We promise.
Yeah, promise. Look, we've got a lot more chocolate on this turd. How many times
a lot more cake in this broccoli casserole?
Okay, yours is less vile. So this decision was towards the end of June, but I think it was before the Mahmoud decision came out.
It was a week before Mahmoud, yeah.
Yeah, it was a week before Mahmoud. So who knows if the justices, I'm sure the judges in the Fifth Circuit case were aware of the Mahmoud arguments, and all of that stuff, considering such, what a high profile case that was, in the First Amendment sort of school circuit.
Right. Which is interesting because at one point in this case, the judges say, like, when they're talking about the coercive effect of kind of the potential of having the 10 Commandments on the walls and just like what that could do to kids. They mention that students can't opt out of seeing the 10 Commandments. And,
Which could be a direct reference to the arguments from Mahmoud. We don't know for sure.
Right.
But like,
because Mahmoud would kind of say like, well, maybe they could because this is like clearly normative, right? Like it's the 10 Commandments. It's about morality.
Yep.
And is it being presented in a non-neutral way? Potentially, right? So like there could be an argument that Mahmoud would require an opt-out. But again, how do you require a systematic opt-out?
Yeah. Anyway, and the Texas law also just became law possibly before the Fifth Circuit ruled on this.
In May, I think.
Oh yeah. So it was before the Fifth Circuit ruled in this case. So this is all really interesting. Like you said, there's a lot of stuff that's happening within these sort of legal frameworks, a lot of negotiating, a lot of wrestling, fighting, whatever, that will hopefully over time provide a little bit more sort of establishment clause clarity. It's going to be interesting to see how these historical context arguments evolve, what sticks and what doesn't stick, parental rights, the opt-out, like there's all of this stuff is kind of interconnected, right?
Right. And it's all the site of interpretation and conflict. And like, just because the Supreme Court has spoken doesn't mean there's clarity.
Yes. That's depressing.
Or empowering.
Okay, let's go with what you said.
Half empty, half full. Let's go.
There you go. So there you have it, folks. The Louisiana 10 Commandments law is on hold pending either a full sort of litigation, trial, whatever, or appeal to the Supreme Court. It's just on hold for right now. We don't know how this is going to play out there. We don't know how it's going to play out in Texas or in any other states, but we're going to keep our eyes on it.
Right. We've already done 2 or 3 bell ringers on this in one episode.
Are you sick of this yet?
Let's do another Groundhog Day episode.
Here we go. All right. Well, that does it for today. Chris, take us out of here. What's our homework?
Your homework is to go fill your glass half full.
Oh, that's so inspiring.
Right? Yeah, I try. Like, rate, review, Chalk and Gavel, wherever you get your podcasts. Your support means so very much to us. We're going to keep bringing you the fascinating education law content as long as, courts keep doing this stuff and you all keep listening. Let's see. You can find more information at chalkandgavel.com. You can find our teaching guide, links to our Patreon, patreon.com/chalkandgavel. Your support, again, it goes a long way to helping us make this show. All right. Well, to those of you in schools in one form or another, I hope you're having a great start to your new school year. And wishing you all the best, and we'll see you again in 2 weeks. Take care, everybody.